Okay, thank you, Barbara. Is the mic picking up okay back there? All right. Well, I thought we'd start by having our two guests kind of describe their involvement in litigation, raising same-sex couple kinds of issues, just to give the audience some background about what you've done and how you've been involved. And I don't know which one of you wants to begin, but why don't you both describe your involvement?
So Indiana was involved with not only briefing our own, in defense of our own state statute defining marriage, but we also chipped in to help other states defend their traditional marriage definitions, including California, where, as so famously happened, the state officials chose not to defend Proposition 8, but instead left it to the Proposition 8 initiative advocates. And we filed an amicus brief both in the Ninth Circuit and in the U.S. Supreme Court supporting Proposition 8. Eventually, of course, the Supreme Court dismissed the case because there was no suitable defendant to carry on the defense. And instead, the court issued its decision in Windsor by itself, and that precipitated a whole range of new lawsuits challenging state traditional marriage definitions. The tide reached Indiana in April of this year, and I think we're on the receiving end of 5 lawsuits, all filed within a few days of each other, challenging our marriage definition. And I became the lead counsel for the state to defend traditional marriage from those challenges, which were now all about the federal Constitution as opposed to the state constitutional issues I'd litigated so many years before. And I remained with that case until October 6th, when the Supreme Court denied cert, much to my chagrin. And so that's the summary of my experience.
Okay, well, first, I really want to apologize. I think I'm a weak stand-in for the person who was supposed to be here. But my involvement in this issue really is entirely state-based. I opened my practice, as they said, in 1992, and from even before I opened, I've worked with members of the LGBT community to figure out ways to establish and protect the rights of families as they could under the laws of Kansas as they exist. And that's been a very tough thing to do because, frankly, the laws don't protect LGBTQ families in all sorts of ways. And so it's been a nonstop struggle for 25 years, more or less. After Windsor, first of all, I was excited by Windsor. I was particularly excited by Justice Scalia's outline of the arguments that proponents for a change in state courts should follow to get state courts or state decisions affecting state laws changed. And I actively said that, to all of my clients and to any members of the community who would hear me, that if there were people who were interested in filing suit to protect their rights or to establish their rights to marry, I'd be happy to chat with them. I actually ended up talking with over 30 couples about various aspects and avenues for pursuing a legal challenge to what is the law in Kansas. And when all the dust settled, 2 couples actually agreed to hire me and to pursue an action. But I'm a state law attorney. I do divorces and child custody, and I'm in Douglas County Court all the time. I'm not in federal court. In fact, I'm not even sure my federal court license is active. But I wanted to pursue something in state court to get a remedy that wouldn't necessarily put the judges on the edge of their seat saying, oh, we're challenging the Constitution, but just to get some open door for my clients to start to recognize their rights as couples. Now, my clients are married. There are 2 couples, one gay couple and one lesbian couple. They were both married, ironically, in California. I've got lots of clients. It's funny, most of them are married in Iowa, but the clients for this particular suitor were married in California. And they had approached a very prominent attorney to discuss some sort of federal court action, and that attorney had told them they'd need $250,000 to do it. They didn't have that kind of money. My estimates were significantly less, and they liked that aspect of life. So anyway, we began a kind of mutual investigation of the law. About the time they had hired me, the state of Kansas Department of Revenue issued what the state is calling Notice 1318. And that notice essentially says that for married couples, married same-sex couples who've been married legitimately in some other jurisdiction, that when they file their income taxes in Kansas, they have to file as single persons. Now, as you may know, as a result of Windsor, for federal tax purposes, legally married same-sex couples, no matter where they were married or where they reside, have to file their taxes for federal purposes as a married couple. So that opening, or I saw the issuance of that notice by the Department of Revenue as a potential opening, and I began reading the tax code. Now, I've got to tell you, I read it 3 times, and I've got to tell you, it's the biggest bore there is. But what I discovered is there's a statute that specifically says that for tax purposes, the Kansas Department of Revenue has to use federal definitions for federal definitions for tax purposes, period. And by argument, that means that if the federal government defines a same-sex legally married couple as married for federal tax purposes, it seemed to me that statute requires Kansas to say they're married for tax purposes. As I worked and investigated more, it seemed to me that this notice, which just says notice, is really a rule and regulation. And there's a whole body of Kansas law, as there is in many states, but a whole body of law about how rules and regulations are adopted. They have to publish notice and give public hearings, and there's a whole series of things that have to happen. But in this case, the state didn't do any of those things. The Department of Revenue just kind of printed out the notice, put it on the internet, and said, here it is, folks, you got to do this. Now, the thing about that notice is it requires a bunch of things, and just a few of them. Same-sex couples have to file singly, even though they file, and the notice acknowledges that on the federal level they've got to file as married, but in Kansas, no, you have to say you're single and file as unmarried. That requires you to do your taxes twice, first of all. It requires you, in my mind, to commit perjury because you have to say you're not married when you are. And by the way, those marriages are recognized in the states where they got married and by the federal government. It's not as though that, they went to Joe Blow at the corner who got his, priesthood degree on the internet. This is a legitimate marriage. So anyway, I'm thinking this is a rule, this is a regulation. They got to do all this stuff. It's under penalty of law. If they don't do it right, they get, the Department of Revenue can sue them. So I think this is a regulation. That's not right. Now, when you're doing this kind of thing, there's something called exhaustion of administrative remedies. And this is a very difficult concept for folks who want to challenge state laws and regulations because you have to exhaust your remedies. And what that means is that in theory, if these people wanted to challenge something about the Department of Revenue or something on their tax return, if the IRS, for example, said they owe $1,000, and my client said, oh no, we only owe $500, then you have to file an appeal. You go to the Board of Tax Appeals or whatever it is, and you let them decide about whether you're right or not. And once you've exhausted all those administrative remedies, then you can go to district court. Now, my clients did not want to do this. They did not want to file their taxes, wait and see whether the state accepted it or, They wanted to just get a decision. And not so easy to do. So what I determined in my investigations, there is a clause in the statutes about challenging administrative regulations that allows you, if you're challenging the constitutionality of a rule or regulation, or if you're challenging the way the rule or regulation was implemented, then you don't have to exhaust your remedies. You can go directly to court. So I said, aha, I've got something here. And we thought that was good. Now, the other thing is I'm still really enamored with Justice Scalia. Now, I know that's a weird thing for a liberal person to say, but if you have looked at the Windsor decision, I'm not a constitutional scholar, I don't know, but he literally outlines the arguments to make on a state level about why state laws are unconstitutional. And I thought, this is great. Why can't I do this? Well, I was a little concerned about that. But the rule and regulation that says that same-sex couples can't be treated the same way as other married couples seemed to me to be just as discriminatory as the law that was challenged in Windsor. It creates two classes of people for unreasonable reasons. Maybe I can use Justice Scalia's arguments, and indeed that's exactly what I did. I used those arguments and I argued that Notice 1318 is unconstitutional because it denied my clients equal protection under the law and it denied their rights to due process. That's kind of the basis on which I sued. We sued back in December of 2013. We have no decision. We have oral arguments. They're set November 14th in my case. The state has argued, not surprisingly, my clients didn't exhaust their administrative remedies, therefore we can't have any hearing in court. I don't think their arguments have merit, but they're saying that Notice 1318 is not a rule or regulation, which is the kind of the door I follow to get in to file this lawsuit. They say, oh no, it's not a regulation, it's just a guidance document. Okay, obviously I disagree. The court hasn't decided. We'll find out about that. But in their arguments, they say, well, we're relying on the state constitution that now says that marriage is a civil contract between a man and a woman, and the marriage statutes in Kansas that now also say marriage is a civil contract between a man and a woman. So this has opened the door for me to say, well, you know, the basis that the state is using to justify their notice is unconstitutional too. So my goal when I first met with my clients, and again, this was summer of last year, Windsor had come down. There were cases pending in many states, not all, but there were cases pending in many states. There had been no decisions whatsoever. We didn't have a clue what would happen. And we were really shooting in the dark about how to approach this. And what we decided about my particular case is that it gave whatever judge was going to end up deciding this case a range of options. One is a very non-political, non-threatening kind of thing. The statute says you're supposed to use federal definitions. You didn't use the federal definitions. Therefore, the regulation's void. Or it's a regulation, you didn't adopt it properly, it's void. Neither one of those touch on this emotional battle about constitutionality of same-sex marriage, equal protection, or any of those things, and we thought that if the judge were being cautious, we could win on that argument. But a part of that argument gets to the point that the state still has to recognize the marriage from out of state. And that was really our goal in the long run. And if the judge wanted to address the constitutional arguments, super. You know, declare the law unconstitutional. We will be very happy with that. But again, we wanted a range of options and tried to structure it so that we would basically ensure as much chance of success as we could.
So if you're a self-confessed non-federal con law, maybe I'll direct this to Tom. You want to explain a little bit more about the Seventh Circuit case you were involved in and kind of the issues that were being argued, equal protection, due process, and you know, if you want to a little bit explain the arguments on both sides, but certainly articulate what you were trying to accomplish and
Sure.
what the court said.
Right. Well, our case, as I think with most others around the country at this point, presented both the issue of whether Indiana had to license same-sex marriages and also whether it had to recognize same-sex marriages from other states. So there's some overlap, it sounds like, between our cases, although I think there are types of remedies that the plaintiffs were seeking in our cases were not necessarily tax-related, although sometimes they were. We had a whole variety of plaintiffs that came into court. And these plaintiffs challenged our traditional marriage definition, both on federal equal protection and so-called substantive due process grounds. They also asserted a few other interesting claims. My favorite was a violation of the right to travel, and there was also establishment clause, full faith and credit, that sort of thing. But those mostly all fell by the wayside one way or the other. And by the time we got to judgment, the the judge had made it pretty clear he was focusing on the equal protection and due process claims. So Judge Young, our district judge, enjoined enforcement of the marriage definition, both as applied to licensing and as applied to recognition. We had litigated this case very quickly. I think everybody realized that there weren't a whole lot of facts to gather. We all knew what the score was, so to speak, nationally, and what was at stake and what it would take to litigate these claims. And we didn't want to spend a lot of time either learning more irrelevant information about one another, or I think neither side wanted also to bring in any experts to testify about any angle of this. It just didn't seem to really match the nature of the legal arguments that either side was making. So we were able to litigate this fairly quickly, both in the district court and then ultimately on appeal. So I think, as I mentioned, the case was filed. I think it was early April. It's hard to remember now. It was either late March or early April. But we were able to get a judgment from the district judge by the end of June, which is very quickly in federal court timelines. We, from there, requested a stay of the injunction, ultimately got one from our regional court of appeals in Chicago, the Seventh Circuit, so that none of the injunctions would have to be carried out while the appeals were pending, because if once the marriage licenses are issued and other steps are taken, you're not really going to be able to undo any of that down the road. So fortunately, the Seventh Circuit stayed the injunction while we appealed, but at the same time set a very quick briefing schedule. So we were expected to file our briefs within weeks of the notice of appeal. Again, this is an unheard of timeline. And ultimately, we argued the case now all the dates are, I think it was in August, late August. And that was a pretty unusual experience. That was an interesting argument to be a part of. Full courtroom, 3-judge panel in Chicago, Steve's old boss presiding, asking me questions. If I remember it, I've kind of put it out of my mind at this point. But so no, it was a challenging exchange. It was a really interesting experience. I'll say that. But what even more interesting is the court only took 9 days to issue its decision. So I bet of all the lawyers in this room, I can probably lose a federal case faster than any of you, because I've demonstrated on this one. Well, we knew, again, that there were many other cases pending around the country from the 10th Circuit, from the 4th Circuit especially, that were making their way to the Supreme Court and had judgments from the regional courts of appeals well before ours, had been waiting for the Supreme Court to come back from summer recess before it could consider the petitions for review, all of which is discretionary. The Supreme Court doesn't have to take any of these cases. But we learned the day after our Seventh Circuit decision came down that if we got our cert petition in the following Monday and the other side got their response in the next day, that we would actually be considered alongside all of the other cases that the court was scheduled to take up at its conference that was coming up. Well, this had been one of our goals from both sides of the case all along, was to try to figure out a way that we could get into that mix. Every case has its differences. As far as the Supreme Court is concerned, there can be any number of factors that make one case a better vehicle than another for purposes of deciding such a momentous issue. And that may depend on the whether it's a constitutional provision or a statutory provision being challenged. It may depend on whether the state is defending and the state attorney general is involved, or as in Virginia, the state attorney general has backed away and handed over the defense to somebody else. Who are the players, so-called, that the Supreme Court wants to hear from? All kinds of little differences. And so we thought, we're not sure. We don't know exactly what case the Supreme Court wants to use, but we were really confident that they wanted a case. They had granted review in the Hollingsworth case. They decided Windsor. It looked like the table was set, ready to finally take care of this issue. And I think lawyers on both sides wanted that to happen and expected it to happen. So I threw in the towel on one more weekend and churned away and managed to get my cert petition on file on the Monday morning. Monday afternoon, I guess. But in any event, we got everything ready for the Supreme Court, and they distributed the papers, and sure enough, the court considered our case right alongside the others. And on Monday, October 6th, flushed us down the toilet along with all the others. So we did not get the review that we had hoped for and that we'd been expecting. But along the way, we had a very in-depth review of both the equal protection and the due process arguments. Now, from the plaintiff's side, it's probably easier to start there just because of it sort of establishes a point-counterpoint kind of feel for all of this. From the plaintiff's point of view, it's a straightforward theory of, well, look, you grant marriage licenses in recognition to opposite-sex couples. Why not same-sex couples? They seem to be equal. There's no difference between the two. What can possibly explain this distinction? And it must be, something to do with animus. It must be something to do with the same reasons that we see historical discrimination against homosexuals, and that's not permissible. So, state, come forward, explain yourself is kind of the way these things get set up. That's the basic equal protection theory. The due process theory is more along the lines of, there are all these cases where the Supreme Court has said that there is a fundamental right to marriage. And it was speaking in those cases, in cases that were opposite-sex couples, but it was doing it in a variety of circumstances. And so the same-sex couples have been saying, well, look, if there's a right to marry, then that applies to our relationships as well. And you're not permitting that, so how can you, not come forward with those rights that we think the Supreme Court has said exist? Again, state, what do you say? Well, our response has been, to approach this from the standpoint of what governments do. What are governments in the business of doing? Well, governing. What does that mean? It means typically regulation. It's easier, I think, in many ways to start with the substantive rights issue because I think the nature of substantive rights that the Supreme Court has reviewed over time has been one based not only on text but also in history of the Constitution. They've announced many times that if you're going to try to establish a new constitutional right, you can't just say seems like a good idea, that seems like this should exist, but you've got to have some rooting in the text, history, and structure of the Constitution. And from the state's point of view, that simply isn't there for purposes of same-sex marriage. You just can't find the same historical roots for it that you can for traditional opposite-sex marriage. And so that's actually a fairly straightforward argument there. I think the argument from the plaintiffs tends to be, well, if there's a right to marriage, it's a right to marriage, and it doesn't really matter who's participating in it. It's the same right. But I think it's, from my humble perspective, pretty hard to stretch that traditional marriage definition to go to same-sex couples just, on the face of it. The equal protection argument is perhaps more interesting because it really shows, I think, the different worldviews of the two camps in a way that maybe the due process issue doesn't. And it does this by the nature of how we ask the question. So from the standpoint of advocates for same-sex marriage, the question is always, what justifies denying this? And from the state's perspective, the question is flipped around. It's, well, what justifies extending it? Why would we do this? And again, I get at that from the standpoint of state regulation. Marriage is a regulatory scheme. It's a way to encourage, I'm going to repeat all the arguments many of you have heard over time and time again, and that I've written many, many times, but the theory is this is a way to encourage potentially procreative couples to stay together for the sake of their children. It is a means to encourage voluntary regulation. People enter into these relationships. They are regulated by the state. There are limits put on activity that can happen within that relationship. And it is a way for the state to accomplish some very important goals. The state wants to discourage abandoned children and wants to encourage children to be raised by their biological parents. Those interests simply don't extend to same-sex couples. The regulatory rationale that we have for opposite-sex marriage is missing. And if you want to ask a question about why deny, you first have to establish that the two groups are equal in all particulars, in all relevant particulars, and in our view they're not. And that extends over even to the point of, as Judge Posner, I think, was articulating it, why deny this right? Well, there is no right unless you go through the historical analysis and that exercise. From our perspective, the Constitution doesn't permit the presumption of the existence of the right and then force the state to justify denying it. You have to first go through the heavy lifting, the historical heavy lifting, to establish that the substantive right exists. And that's where we ran into problems with the Seventh Circuit, where Judge Posner was very much committed to the idea that the way to analyze this was simply to go through a cost-benefit analysis of what is the cost to the state of extending marriage recognition and licensing to same-sex couples, versus what is the benefit to everybody for doing that. In his view, the state came out on the short side of that cost-benefit analysis, which I think is an improper way to look at the constitutional question, whether you're thinking in terms of equal protection or due process, because states have the authority to establish their own marriage rules and regulations, just like any other use of their powers. And federal courts are not typically in the business of second-guessing states on the costs and benefits of their regulatory affairs. So it's in many ways an argument that it oftentimes doesn't satisfy either side of the debate at large. It is a position that we have taken based on our limited role as the defenders of government and representative government at that, as opposed to others who may have other reasons that they prefer one system or the other. But it's simply a question of what is the proper reach of the regulatory state and what are the limits of extending regulatory treatment. And in the state's view, this was simply not an area where the state belonged.
Okay, let me ask you both a couple of questions, and we'll try to do these a little more quickly. I want to have time for audience questions, but you were asked this question at dinner. I'd just like you both to kind of, for the audience's sake, what's your response to the argument that same-sex marriage is just like bans on interracial marriage 40 years ago? Is it the same? Is it different? Why? What's your position on that?
Okay, I'll go first. First of all, I think it's the same legal issue in many respects. I really want to address some of the points Tom made, only because I have a feeling that the other side didn't quite get represented. The courts, there have been, if I'm not mistaken, 41 or 42 court decisions on these questions. The arguments that Tom presented have been presented in every one of those cases. And so far, the tally is 2 for Tom's side, all the rest for the opposite side. And what the courts say in a very technical way is they say, Tom's arguments are bogus. And I'm sorry.
Is that Latin? Is that bogus?
It is, exactly. Bogus, bogai, bogum. But the idea that marriage is to protect the rights to bear children or to raise children or to ensure parenthood, those arguments don't hold up in today's society. Many people get married without ever any thought of having children. If a couple at age 60 decides to get married, the chances of them having children is relatively small. Modern science is pretty good, but still the chances of them having children is pretty small. And furthermore, with the divorce rate at more than 50% for married couples, children are not being raised by their biological parents. They're being raised by step-parents and all sorts of people, grandparents and who knows whom. But the point is that those arguments, when you really examine them, don't hold up. And what the argument, this is my phrase, and I haven't seen this in any court decisions, but essentially what they're saying is, we always did it this way. It worked okay. What's the problem? Well, the problem is there are a lot of folks that don't fit in that little binary thing of man, woman, and they get married and have kids and raise families. And for all those people that don't fit in those little boxes, their rights are not being protected. there is a long history, as Tom said, of the Supreme Court specifically saying marriage is a fundamental right. He's absolutely right. Historically, same-sex couples have not stepped forward and said, we want to claim that right. But they are now. And realistically speaking and practically speaking, why not? The arguments that same-sex marriage somehow threatens opposite-sex marriage are, again, in my legal terms, sort of bogus. I mean, you know, for those of you who are married in this room, if you're married to someone of the opposite sex, if the person sitting next to you marries someone of their same sex, how does that affect your marriage? I would argue it doesn't. I would argue that they can be taxpayers, family members, they can raise kids or not raise kids as they choose to do, and that's what the courts have said in a variety of different ways. Those arguments that, and again, that's unfortunately, you know, for Tom, the reason he keeps losing is that those arguments aren't being accepted by the courts. I think, realistically speaking, I think if we go back to the time that Loving was decided, I have a feeling that if the courts were presented the cases that are coming up now, or if they had the Windsor facts, they would not rule the way the Windsor court ruled. They would find some other way to decide that case. Times change. There is no question about that. But if you accept that marriage is a fundamental right, then as in Loving, where the court said the state doesn't have the right to say that interracial marriages should be banned, today the courts are saying there's no reason for the states to be banning same-sex couples. To get back to your question, I think it's the same issue, just kind of with different clothing.
Well, we don't have to speculate about what the court thought of same-sex marriage back when it decided Loving. Within 3 years of Loving, they disposed of a same-sex marriage case out of Minnesota, a case called Baker. And they decided that it did not present even a substantial federal question. It didn't warrant plenary review with a full-blown opinion. They just dismissed the case. It was that cut and dried in their view. The break with the parallel is over anti-miscegenation laws is actually pretty dramatic. I mean, the common law countenanced interracial marriage. It was part of the common law tradition. There was no anti-miscegenation at the common law. It was an American invention and, you know, unfortunately permeated not just southern states but other states as well. Never reached all states, but it was not part of the common law tradition, which informs so much of our constitutional history. On the other hand, you know, traditional marriage was the common law definition of marriage for going back eons, and it simply has no parallel in that regard to anti-miscegenation laws, and that history is very significant when you sit down both to analyze that particular question, but then also to ask whether there is some sort of historical rooting of same-sex marriages in U.S. constitutional tradition, and it's not. There's just not. And it's not just a matter of people stepping forward to claim rights. It's a question of whether society was ever prepared to create those rights or accept those rights or acknowledge those rights, and society never had done that. I think the problem in terms of understanding marriage, same-sex marriage vis-a-vis opposite-sex marriage is that I think we're too busy looking for the immediate impact as opposed to asking the deeper question, which is, what does it mean? Why do we have marriage? Now, many people don't live now the way that families lived 40 years ago. I get that. But to the extent that that means that marriage has to be redefined, that's not a function for federal courts. That's a function for state legislatures. That's why we elect people. We elect people to go and make laws that reflect the way that we live now. And if it means changing a fundamental definition of marriage, then that's something that can happen. But then we have to ask ourselves, if we're changing this definition, if we're going from a system where we understand marriage to be between one man and one woman to something else, what is it? Why are we doing this? And what are the limits on that? Are there any? Are we creating a system where there is no government purpose at stake? It's only a matter of what individuals want to define for themselves. And if there are no limits to it, then culturally, how far are we prepared to go with that? Those are some very difficult questions. And they're questions that are not answered by 40 or whatever U.S. Court of Appeals decisions and district court decisions that come out around the country. It's very disappointing in a way that the courts have not seen their way to even try to grapple with that question of whether there are limits on these claims and whether they can extend to other relationships, plural marriages, for example, that we traditionally have not countenanced, and in fact that are part of the founding documents, statehood documents of a few states. So I think that we do have to ask those deeper questions and ask ourselves what are we changing from, what are we changing to, and if we don't, defer to a state legislative definition of marriage, whose definition are we going to accept?
Do you want to comment on that?
Yeah,
Because
I
that
do.
raises a question. I was going to ask sort of the institutional role, courts versus legislatures.
In some respects, I agree with Tom wholeheartedly. I disagree that we're changing the definition of marriage. I think we are making marriage available to all persons, and to me, it's a true equality question, not a question of what the definition is. Marriage has historically been a civil contract between two parties that enable them to take advantage of various civil benefits by law. And, I think there are various numbers that are batted around, but currently under federal statutes, there's something like 1,382 statutes that govern marital relationships, and in Kansas, I think there are 900 and some odd statutes. And they range from various things, from inheritance rights to parenting rights to as simple as, can you go and register your spouse's car or not? But the point is that the definition of marriage is it's a civil contract that entitles you to certain benefits and protections at law. And realistically speaking, from my perspective, whether you're a heterosexual couple or a same-sex couple, that doesn't matter. You should be entitled to claim those same benefits if you enter into that civil contract. But what Tom's right about is that the discussion has not gone down the road to talk about, well, what does happen when we have a polyamorous family who wants to be married? Or what happens, there are all sorts of scenarios you can develop in terms of how do we extend this civil contract to get the benefits of the law. And at some point, the courts are going to be addressing those questions, and to date, they've avoided them.
Well, they have, and it's in part of that has been at the invitation of the plaintiffs in these cases, who assure the courts that the states will surely come up with compelling reasons to argue against plural marriages. And they haven't identified what those rationales might be that they are so insistent surely exist. But I think that's a concession in its own way, that there really is nothing left once we change that definition. I want to point out something, though, about the way that marriage sometimes is thought of. I've described it as a regulatory institution from the state's perspective, and I understand that's not the only significance of marriage, particularly if you're religious. There are other significances of marriage, but I'm talking about from the state perspective. But then there's this idea that it's a contract. Well, it's not purely a contract. We know that. There are regulatory burdens that inhere to the marriage relationship. You cannot contract those away. But to the extent that we talk about history, we have to take all of the history. We can't just take marriage as a history of a contract between two people. It's not that. If it's a history of anything, it's a history that goes back to opposite-sex relationships and not same-sex relationships. So if we're going to invoke history, we've got to invoke all of it, not just the pieces we like.
Let me ask you this question, and we're getting close to where I think we can turn to audience questions. But so given the number of decisions and the direction they've gone, what does an attorney general do in a state where it has not been resolved by a decision yet, but the suit comes up? What sort of, you're in an attorney general's office, but I think you both have an opinion on this. What do state officials do in response to what's going on?
Well, I think you defend. I think there's a responsibility on government officials, especially attorneys general, to defend laws that are enacted by their legislatures. These are perfectly defensible laws. There are many attorneys general around the country who have chosen not to defend it. I think that's unfortunate, and I think that the way that decisions were going both before and after Windsor demonstrate that there is a hotly contested issue here. We've gotten all decisions one way after Windsor, but before Windsor we had them pretty much going all the other direction. There's a history of over a decade plus of litigation where many courts had been agreeing to the very theories that now all of a sudden have become unpopular with judges. So I think there is a meritorious defense to be offered. At the same time, I think state officials have got to be realistic. I mean, they've got to be thinking about these things. How are we going to plan for the day when we're going to have to start issuing licenses or recognizing out-of-state same-sex marriages? It's an unfortunate thing to have to plan for, from my perspective, as one who's defended these laws for so many years. But I think we've got to see the writing on the wall that that's a very there's a very high likelihood that day is going to come.
David?
Well, before this session, Tom and I were back in the back discussing, what is the effect of what's happened so far. We've got roughly between 30 and 35 states where same-sex marriage is now the law of various states, and literally thousands, if not millions, of people have married under those laws. And what's going to happen as a result of that? And he and I agree, there's no way, you can't stop that. Those people are married and they've got various rights, and you can't turn back the clock. So that inevitably, at least in my opinion, Tom did not specifically say this, but in my opinion, I think that it is clear to me that in an astonishingly short amount of time, same-sex marriage will be the law of the land. And to answer this question more specifically, I personally think, attorneys, particularly attorneys general and prosecuting attorneys of all stripes, have a legal obligation to enforce the laws, but they also have an ethical obligation to follow what the courts are saying and what the Constitution requires. And it is clear, although this, in some respects is a change, but it is clear that the law of the land at this point is that courts must grant equal opportunities to marriage to same-sex couples. And when an attorney general or a governor decides to expend the funds of a state to battle in a fight that is not winnable and is not constitutional and is discriminatory against its citizens, it is both the governor and that attorney general are violating their oaths of office and harming the citizens of their state.
Wow. I think that's stunning language. The state officials, such as attorneys general, are elected to defend the laws that are enacted by the legislature. If we have attorneys general running around choosing which laws they're going to defend and which are not based on their assessment of at that level, I think that it's a recipe for the sort of chaos we try to avoid by having attorneys general. And the idea that we would be violating oaths of any type simply by defending the law that and the definition of marriage that's been around for thousands of years is just I don't see that. I don't get it.
Okay, well, let me ask one more, but let's have the mics ready for the next question. So you've sort of been hinting at this all along, but it's the shortest question on my list, which is what happens next? Sort of where do you see the next couple of years litigation-wise? What happens? Does the Supreme Court take a case? What happens?
I'm going back to auto dialer laws. I don't know. Yeah, I mean, there isn't much for us to do in Indiana at this point. I don't know. I assume that if a state Supreme Court or if another federal circuit rules in favor of states, that the Supreme Court's hand will be forced. I'm not optimistic about the state's chances in that event, but it's possible that there may be 5 votes in our favor. It just seems unlikely given what's transpired. So I don't know. I'm not sure I have anything more to add than that.
Fair enough. David?
All right. Well, I've already said, I think that the courts, whether it's the Supreme Court or the various circuit courts, are going to enforce, the law as determined by courts like the 10th Circuit, and they're going to say that same-sex couples should have the same marriage rights as any other couple. But I don't think that, in some respects, certainly for attorneys who have dealt in this area of law, we are only beginning the battles that will ensue. There are going to be all sorts of issues related to parenting rights, inheritance rights. As you may all know, that prior to these decisions about marriage, various jurisdictions enacted domestic partnership laws or a variety of laws to kind of be the same as marriage, but not the same as marriage. And again, thousands, if not millions of people took advantage of those laws. So the status of those relationships are going to be up in the air as states change laws. Some states are saying if you entered into a domestic partnership, then automatically you're married. Well, there are going to be a lot of folks who aren't real happy about that. There are just truly all sorts of issues, and just kind of on the lighter side, but equally serious in the bottom line. I have a number of clients who, because of their desire to be married and the fact that their relationship was not recognized at law, would go to whatever jurisdiction allowed domestic partnerships or same-sex unions of any kind, and marriages once they're in every state. They'd go get married, they'd do a domestic partnership, they'd do a civil union, whatever it was, they went. And in the process, they signed various documents that said, A, they've never done it before, and whatever. And for those folks who stayed with the same partner, well, it's not good, but it's not necessarily awful. But there are a lot of people who've done that with different partners, and they've never terminated those prior relationships. And they all have various effects at law depending on the jurisdictions in which they did those things. So there are people that are going to have all sorts of complicated, extremely complicated problems in determining parental rights or inheritance rights, ownership rights, all sorts of things. So that these decisions, while on the surface seem so dramatic, and they are, we're going to see a tidal wave of other problems as a result.
Okay, fair enough. Questions from the audience?
Thank you. I agree with Mr. Brown's position. It really bothers me that the state would expend time, energy, and money defending this situation. On the other hand, my favorite old lawyer, who acted almost like a surrogate father for me, I challenged him one time, how and why do you defend that murderer when you know he's guilty? His response was, my job, my challenge, is to do the best I can for my client, regardless of his guilt. That bothered me a lot. But that falls in the position of Mr. Fisher, that the job of the Attorney General is to defend the state.
I think you got a vote, Tom.
Yay! Thank you. I think that in my boss, the Attorney General, will often speak in exactly those terms. He compares what we do to the job of lawyers in other areas of the law, and there is a commitment there and a devotion and a responsibility that we defend laws. There are many laws that we personally don't like in the office that we have to defend, and just because it's controversial doesn't make that responsibility any less. And for whatever it's worth, I don't get paid very much, so it's not like that big an expense. So.
You want me to respond as well?
If you'd like.
Yeah, okay. I think there's a difference between defending a law you don't like and defending a law that's been determined unconstitutional by the higher courts. And I think as attorneys, we owe an obligation to follow the laws determined by the higher courts, and we don't get to make those decisions for ourselves. And when it's clear that a state law is not constitutional, I don't believe the Attorney General is serving the public purpose that the Attorney General was elected or appointed to do. I don't believe that Attorney General is performing the functions that he or she is supposed to perform.
Mr. Fisher.
If you have said I didn't get it, what do you all...
Let's take the one in the back, and then we'll come back to
sorry.
the front. That's right.
Mr. Fisher, you say marriage's goal is procreation, which is why same-sex couples shouldn't be allowed to marry. How do you acknowledge transgender people, men who have vaginas or women who have penises, who want to marry someone of the same gender? They would be able to procreate with a same-gender partner. How could you deny to them the right to marry?
Okay, so first of all, let's bear in mind that the rationale for government-regulated marriage is the idea that the state is allowed to prefer and would prefer that biological parents raise the children that they create. And it's to protect children from being abandoned, and that's kind of the starting point. Okay. Are there marginal cases? Perhaps, but to the extent that there are, they've been around for a long time. This is not the center point of the debate over this. The whole debate here is whether to change the definition so that we get away completely from the rationale that I've articulated into another rationale. And if so, what is that rationale going to be? So that, I think is the main challenge for pushing for same-sex marriage, is to define what it is. What's the point of government involvement? Why do you want the government to be involved in your lives and in your relationships? From the standpoint of the government, if there's a regulatory interest, then that's something that has to be accounted for. But where there's not, then we have to figure out what the implications are for the rest of society as well.
Yeah, just my 2 cents is that the courts have almost universally said that this procreation argument lacks merit and really do rely on the concept that marriage is a contract between two people and that it should be an option for all parties, regardless of whether they're able to bear children or raise children or anything else. Again, this is a fundamental difference between Tom and myself. I believe this is a marriage equality issue. He argues that it's a change in definition. And, I'm not going to convince him. He's not going to convince me. This is the essence of the debate that we had.
Yeah, my question is, do you all think it is supposed to be decided by the state or by the federal government? And if you said it, I didn't hear it.
Oh, yeah, no, by the state. Yeah, by the state legislatures. Yeah.
By the federal courts.
Christina.
Other questions? Yep.
Mr. Fisher, back here.
Oh, there. Hi.
You mentioned earlier something about choosing the parts of history that were better suited to our argument or more convenient for us.
Mm-hmm.
Could you speak a little bit more about that? Because my concern is that history is written by certain people in power, and we don't always necessarily know the entire story of what has transpired before us.
Justice Scalia is famous for calling himself a faint-hearted originalist. And the faint-hearted part comes in many ways because he too recognizes the struggles that we have of understanding history and the significance of history. It's never a perfect solution, but it's better than the idea that we can just read into the Constitution the preferences of today. But with specific reference to the discussion of same-sex marriage, I'm just not aware of any interpretation of understanding of history, especially of the common law, that finds recognition of same-sex marriages that in any relevant historical tradition. It's the Anglo-American tradition is one man, one woman, and I'm just not aware of any scholarship that demonstrates otherwise. So I don't think on that particular issue it's that hard of a comparison to make. It can be on many other issues, and oftentimes is a challenge. But I just have not heard that argument before.
My question is following in the same vein, and I'm curious, how can a state justify a ban on same-sex marriage using this historical context of marriage when you take the treatment of homosexuals and same-sex couples into consideration and then turn around and deny that these bans are based on some sort of ill will or malice? I mean, how can you make that argument?
Sure. Yeah, I think the starting proposition has to be, what do we really think happened when society first started recognizing marriage? Do we really think that marriage was invented hundreds or thousands of years ago as a way to discriminate against homosexuals? Or do we think it was invented for some other reason? And if so, what was that other reason? And I just find it implausible to think that marriage, the entire origination of marriage, had to do with discrimination against homosexuals. I mean, the idea of sexuality or of homosexuality versus heterosexuality really is not that old a concept. I mean, it's not something that's been that well understood in any event. So there's got to be another rationale. We have to find, I think, ourselves looking for that rationale. And if we ascribe some more legitimate rationale, such as not my, but the general responsible procreation theory, as we sometimes call it, then we have to ask ourselves, okay, so why is that all of a sudden not enough? Why is it all of a sudden that we fast forward to the history of discrimination that we do know about with respect to homosexuals, and why is it proper to take that and project it onto marriage, given the benign historical explanations for marriage? So I think it's not that one denies the discrimination that happens, it's just a question of asking where does that happen, in what context, and does that include marriage? And I think the answer is no, it just doesn't.
Yeah, I obviously have a different perspective on that. Over time, things change. If we go back far enough in history, the idea of slavery was a very popular thing. I mean, you can read about it in the Bible as an appropriate way of dealing with your lands and your property, and all the way through up until the Constitution of this country, which includes counting slaves as 3/5 of people. But times change, and the institution of marriage has changed greatly. It's changed from a religious institution to a civil institution governed by laws of states and nations. And as the state adopts and starts instituting regulations governing the relationships between two people, to say that two opposite-sex people can take the benefits that are offered by the state, but to say that the same-sex couple who wants to encourage their relationship and enjoy those same benefits can't because they're of the same sex makes no sense conceptually. It's a clear violation to me of the due process and equal protection rights that we're all supposed to have. Once the state steps into the regulation of a relationship, then you have to examine what is going on here. And the justifications of parenting and rearing children or all those things, if you examine them, don't have any merit, because the state allows all sorts of people to get married that can't enjoy any of those benefits, or who, even if they're able to, choose not to. So how can you create these two classes of people and justify it by saying, oh, well, this is just our historical definition of marriage? The historical definition of relationships between people would have allowed slavery, would have prevented interracial marriage. There are all sorts of things that if we go back far enough in history, we can't do. But times do change, relationships change, and the state's taking on this role of regulating relationships between two people opens it up to how come these two people get a whole lot of benefits and protections, but these two people don't? It makes no sense conceptually, and that's what the courts are ruling.
So far, a lot of the arguments that have been presented nationally and here have focused on binary groupings, a pair of people, a man and a woman, or a same-sex couple. I wonder what both of your thoughts are on the school of thought that prescribes a more unary approach, where you take, instead of the idea that a same-sex couple has the right to get married, that a man or woman has a right to get married to whomever they please from a gender equality perspective.
You go ahead.
I'm not sure I understand the question. Because I think, essentially, I have been arguing that a man or a woman should be free to marry whomever that man or woman or transgender person decides they decide to marry. And Tom's position is that it's an opposite sex option. But when you take it down to the individual, we're not saying folks have to get, neither one of us are saying folks have to get married, I don't think. You saying folks have to get married?
No.
I didn't think so. But when you get down to it, it is a matter of individual choice, and I'm saying that an individual should have the opportunity to marry whomever that individual decides to marry. And again, Tom's position is slightly different, but we've never, I don't, again, I'm not positive I understood the question, but I hope I've come close to answering.
My only thinking about it is, I don't know, once we throw out the definitions and limits of marriage that we've understood for thousands of years, I don't know where it takes us.
My question takes us beyond the borders of the United States, and it is precipitated by the references tonight to the common law tradition. I'm wondering if your immersion in this subject has carried you to the knowledge of what happens tonight in Canada, New Zealand, Bermuda, in Australia, and would this type of discussion be carried out appropriately in other common law tradition countries? Summing up, where is the issue tonight in Canada, New Zealand, Australia, Bermuda, and other countries that have adopted the common law tradition?
I confess I don't know the answer. I'm fairly confident Canada has adopted same-sex marriage, but I don't recall if it was by statute or by judicial ruling. In any event, of course, the tradition we're talking about here is the Anglo-American tradition that came over with the settlers and permeated the colonies and became the foundation for the legal order that we have, and then we've developed that on our own, and adhering to the English constitutional maxims and provisions and principles that gave rise to the rights that became the foundation for the U.S. Constitution. So it's out of that tradition really that I'm talking, and to the extent that the other common law countries have adhered to that or gotten away from that, I'm not as familiar with. So I think that it's quite possible that other common law countries might have taken a detour that we wouldn't necessarily account for in our doctrine or in our understanding of the U.S. Constitution.
Justice Six, I believe, although I'm not positive, that every one of the countries that you identified have recognized and allowed same-sex unions. Again, I'm not positive. As in most of the countries in Europe have also, I think mostly by legislative action, but not entirely, have also adopted and allowed same-sex marriages. There are still a number of holdouts throughout the world. South America is not a great place. Africa isn't a great place. But worldwide, the tide is turning as well. But same-sex marriage has been legal in Canada for quite some time. In fact, Mrs. Windsor was married in Toronto. Mm-hmm. So.
I think we would do like two more questions, so one in the back and then last one here.
You guys said you guys said earlier that there was about 35 states that have introduced some type of legislation regarding same-sex marriage, and we've been mentioning like other countries around the world that are starting to build up to something like this. And you guys also said that earlier you guys were discussing privately that you can agree there's at least some kind of momentum going on in the public in favor of same-sex marriage. I guess my question would be more directed towards Mr. Fisher, but do you think that there should come a point where the federal government should step in and say, like, we're spending so much resources fighting this, we should just see like the writing on the wall and get this, be done with it, move on? Or do you think it's something that the state should fight for until it's the last state down?
The federal government has no power to define marriage for the states. States can do it.
The Supreme Court would differ with you.
No, but he's talking about the federal government. Congress, the federal executive can't define marriage.
Yeah, right.
Okay. You mean the judiciary? Oh, okay. Well, it's not a question, in that sense, it's not a question of time. It's not a question of understanding about resources. It's a question of law. I mean, are they, I would have thought we would have the U.S. Supreme Court taking up a case or two to, weigh in on this. And I think both sides of the debate would very much welcome that, regardless of the outcome, quite frankly. I'd rather we have a uniform understanding of the law. But it'll be because of those legal reasons, at least in my idealistic mind, not for so much the cost and benefit of litigation.
Yeah, and I just want to clarify one thing. First of all, I don't know the exact number of states right now that where same-sex marriage is legal. It's somewhere between 30 and 35. But it's legal in those states due to a combination of factors. Some states it's because of judicial action. Some states it's because of legislative action. But you can't say that the legislatures enacted it in 35 states. That would be inaccurate.
We'll do one more question, then we'll close.
So tonight you talked a lot about the traditional definition of marriage, and it seems like the bulk of support for that definition is coming from the religious sector. And so I was just wondering what consideration, if any, do you think should be given to religion when you're discussing matters of same-sex marriage?
It depends on where and why you're discussing it. It's not something that we discuss in our briefs. We don't justify marriage based on religious traditions. It's a question of what's an appropriate governmental regulatory scheme look like? What are we regulating? Why are we doing this for strictly utilitarian reasons, essentially? But if you were debating this at within your church or your temple or your mosque or whatever, that's going to come into it. That's a completely different setting of debate, and there can be different understandings of marriage depending on the context where you're discussing it. So yeah, from our perspective, it's never been about the religious angle.
I mean, and he's right. I mean, if government were to say, because religion A defines marriage this way, we're going to define marriage this way, it would instantly be subject to challenge because government can't do that, simply put.
All right, do you want to close? I think we should thank our panelists, and we are concluded.